Hi, everybody. My name is Brian Elliott. I'm the outreach attorney at ALRP. Thanks, everyone, for joining us. Share my screen. So anyway, I'm just going to begin. So once again, my name is Brian. I'm from ALRP. I want to thank the HIV Legal Services Fund of the American Bar Association HIV/AIDS Impact Project. Their generous fund makes it possible for us to bring this training to you today. This webinar is going to go from 12 to 1:30. We can maybe have we're not going to probably have time for questions, but you can talk to Jim afterwards, and this will be recorded and put on CLE Hero later if you miss any part of this. So you should have received materials from me in an email yesterday. If you haven't gotten materials, specifically Jim's slides, I'll put my email in the chat so you can follow up with me and I can send those slides over to you. You will also, there's going to be at the end of the presentation, there'll be a link for the survey. You need to take the survey in order for me to send you the MCLE certificate so that you can get your MCLE credits. This is an hour-and-a-half presentation, so you'll be able to get 1.5 hours of general CLE credit with for California attorneys. Like I said, I will put a link for the survey in the chat, and it'll also pop up when you exit out of the Zoom call. Also, just so you know, we have another CLE coming up on December 8th. That is with Gina Cho, and it's a special competency credit MCLE, so we hope to see you there. I just also a little bit about my organization. ALRP is one of the only legal nonprofits I think it's the only legal nonprofit in the Bay Area that specifically works with people with HIV and AIDS. We provide we provide clients with services in two different ways. We have in-house attorneys that deal with housing law cases, specifically evictions, reasonable accommodations, fair housing, almost every kind of housing type legal matter. We have a benefits attorney. We have immigration attorneys. We do simple end of life documents. So those are the types of cases we handle in-house. For legal issues that we do not handle in our office, we have a wonderful panel of over 700 attorneys that provide pro bono work to our clients. We rely on these wonderful attorneys to help reach as many people as we need to reach. Jim is one of them. So, you know, if you're interested in if you're not already and you're interested in becoming one of our panel attorneys, you know, please email me after this presentation. I'd love to talk to you. But, you know, without further ado, I'd like to introduce our presenter for today, Jim Wood. Jim worked in private practice for almost 40 years as a mix of a trial lawyer representing manufacturers and prescription medicines and devices, as well as doing pro bono practice with Oakland's Crosby Heafy and multinational firm Reed Smith. Jim is now retired from big law and continues to spend most of his time doing pro bono work. Some of the recognitions that he's gotten from us is he's been named the AIDS Legal Referral Panel Clint Huckenberry Leadership Award recipient in 2014, given to the individual whose work reflects a lifetime of service to those with HIV and AIDS. He's been the ALRP he won the ALRP Hero Award for having donated an extraordinary amount of time and expertise to protect the legal rights of Bay Area residents living with HIV and AIDS. And he's won the California Legal Angel Award in 2007 as one of the state's outstanding pro bono attorneys for representation of California school children with diabetes to ensure that they receive care throughout the school day. As a panel attorney, Jim has worked with us for 25 years and handled numerous pro bono cases for ALRP clients, in addition to serving as a board co-chair. Jim represented one ALRP client with a privacy matter that was taken all the way to the Supreme Court. So we're really thrilled that he's here to share his expertise. So please join me in giving Jim a warm virtual welcome. Jim, you're now free to begin sharing your screen and doing your presentation. Thank you.
All right. Well, thank you, Brian. And let me get the technology going here. There we go. Well, welcome all. Welcome from Oakland, California. We're born and raised and continue to practice law here. And again, I'm grateful to the opportunity from ALRP and ABA to provide this third in a series of programs that I presented on privacy. Today, we're going to be talking about litigation, what to do when a client's rights have been violated. In the past, I've spoken about the stigma of HIV and laws and constitutional laws that provide for the right of privacy. And so therefore today, we're kind of wrapping it up on talking about how to protect those rights through litigation once those rights have been violated. She just wanted to be let alone. Mary Smith is an African-American woman living in one of San Francisco's poorest neighborhoods. She's a mother of 6 adult children and is living with a man who's not their father. She became HIV positive while living with him. Her children did not know that she had HIV, and if they did, she was afraid that her children might become violent with him. But Mary needs to go to San Francisco General Hospital every 2 weeks for treatment, but she does not have the transportation to get there, nor can she afford public transportation. City and County of San Francisco provides a transportation service for low-income residents like Mary. The service called Mary at her home to verify her need for this transportation service, but while she was away, her daughter Joan answered the phone. The service asked Joan who she was, and she replied that she was Mary's daughter. When the service asked to speak with Mary, Joan said that she was out. The service asked Joan to have Mary call back so that it could arrange for Mary to get transportation to San Francisco General Hospital so that she could get treatment for her HIV/AIDS. Joan asked the service to repeat what it said, and again, Mary called. It could arrange for Mary to get transported to San Francisco General Hospital so that she could get treatment for her HIV/AIDS. Joan screamed in rage and hung up. And all that Mary wanted was to be let alone. In preparing for today's program, I've taken a look at these resources, all of which have incredible value for a litigator who is preparing to try a case or to work up a case for a violation of a client's privacy. Each of these are unique. Each of these have remarkable resources for background in law, sample pleadings, and so on. The materials that I've sent out today include a Lambda brief that was filed in the case of FAA v. Cooper, which I'll be talking about in a little bit. And it's the Supreme Court case that Brian referred to for a violation of Stan Cooper's rights to privacy. I've also included a sample demand letter that can be adapted for pretty much any type of violation of privacy that you might have. Practicing in California, it's California-centric, but it is a good format for what I believe is a fairly successful effort to resolve litigation through a demand letter. And finally, I've also included a privacy complaint that was prepared in the Aetna class action litigation that we'll talk about in a little bit. Again, there are tremendous numbers of resources available to us in litigation involving a claim to a violation of privacy. The Center for HIV Law and Policy is a remarkable resource for pretty much any issue that you might have as an attorney or litigator, and representing the rights of those who are affected with HIV/AIDS. This particular slide provides a link prepared by Sally Friedman of the HIV Law and Policy. It's a slide and video training presentation for attorneys representing individuals with HIV/AIDS, with an emphasis on what to do in a case where a person's privacy rights have been violated. The program is New York centric. It covers an overview of New York's HIV confidentiality statute, as well as other privacy laws, and has a review of administrative litigation remedies. It provides advice on how to counsel clients, has strategies for choosing legal claims, and so on. While much of the training focuses on substantive legal protections under New York law, there are issues that are very, very helpful as an overview in litigation to help establish clients' goals, to discuss with clients the pros and cons of litigation versus early settlement, confidentiality during discovery, and the effect of a supplement award on government benefits. So this is a pretty good supplement and resource to the program that we'll be presenting here today. Again, HIV Law and Policy has this resource to help a litigator or advocate identify a variety of confidentiality laws as well as cases for all 50 states. It also has sample briefs, sample complaints, and again, a remarkable resource for a litigator beginning in litigation to represent a client whose privacy rights have been violated. As an overview for what we're going to be talking about today, I'm going to go back to discuss the earlier program that I presented on stigma and why it's important, it's critical to present to a judge, jury, opponent, defendant, why disclosure has had such a significant impact on the client's life. I'll briefly go over constitutional and statutory rights to privacy, because these are the foundations for any type of administrative or litigation claim made on behalf of a client. Then we'll dig into the meat of the program and talk about remedies for violation of rights to privacy. That will be an overview of the two parallel rights. They're not independent rights, they're parallel rights. Administrative rights through Office of Civil Rights or state agencies like the California Department of Insurance and Privacy and the Attorney State General. And then we'll dig into litigation and the routes to investigate a claim, to fashion a demand letter, the elements of the litigation, as well as steps to protect and appeal. Well, core to this right is an understanding of various definitions of privacy, and each of these three can be used and should be used throughout, from the time of a demand letter through briefings, perhaps inclusion in a complaint or a pleading, certainly at the time of trial and certainly at the time of appeal. And my favorite one is the quote from Justice Brandeis, and quoting from Boyd versus US, "The makers of the Constitution conferred the most comprehensive of rights and the right most valued by all civilized men, the right to be let alone." And that's what really this privacy claim is about, the right to be let alone. There are protected rights, as we discussed in earlier programs, through the federal Constitution, as well as a variety of state constitutions, including the California Constitution, Article 1, Section 1 of the California Constitution. There's no express provision in the United States Constitution for the right of privacy as there is in the California Constitution. And although the US Constitution does not explicitly state that there is a right to privacy, various Supreme Court decisions involving laws that criminalize sodomy, the use of contraceptives, and abortion have extrapolated the right to privacy from the 14th Amendment. However, the California right to privacy, and this is tremendously helpful to us practicing in California, that the very first article, the very first section of the Constitution provides that every California resident has the right to privacy, an inalienable right. And California's constitutional right to privacy is far wider than the federal government counterpart in that it protects individuals not only against violations by state and federal government entities, but also against violations by other individuals and private companies. Federal complaints are limited to state action. California is against government entities, corporations, businesses, individuals. The Constitution in California, the right has been said to be self-executing and therefore confers a judicial right of action on all California residents. Other states do have a variety of constitutional rights. California and Alaska are the only ones that have the very broad protection, while the other states listed on the slide here are pretty much limited to search and seizure, but can be useful in extrapolating a right to privacy in the unlawful disclosure of HIV status. The stigma of HIV/AIDS is really the core of any claim for a violation of privacy. The stigma associated with HIV/AIDS is at the heart, and must be at the heart of any proceeding, any claim for a violation of privacy. In past programs, we've discussed the stigma placed on the community and those with HIV/AIDS. And I'm bringing it up again briefly because it is the stigma that will persuade courts and legislatures to adopt protections for privacy, as well as to persuade triers of fact and courts that a person should be compensated for a violation of their privacy by disclosure of their HIV/AIDS status. For that reason, I'm going to go back and take a brief look at the stigma and all the various factors which become the core of any case that we take. The impact of disclosure of HIV/AIDS and the stigma related to it has an impact across an individual's life in every step of life. For example, in a Williams Institute study from UCLA, said that healthcare providers in Los Angeles County have 46% of skilled nursing facilities, 26% of plastic and cosmetic surgeons, and 55% of obstetricians would not take a patient who was HIV positive for any type of service, even though they were asymptomatic. Research by the International Center for Research on Women outlines the possible consequences of the HIV-related stigma that are identified in this slide, along with loss of reputation, loss of hope and feelings of worthlessness, withdrawal of caregiving in the home, and so on. And it's because of the stigma that the courts have found them to be the actionable basis of a personal claim. Again, which should be a major item throughout your representation of the client in your demand letter, trial memos, jury arguments, and appeal. And the citation from Urbaniak here in California provides a good and persuasive introduction to the impact of the stigma for the improper, illegal, and unconstitutional disclosure of a person's HIV/AIDS status. Again, these two cases are other examples that you might want to cite throughout the lifeline of a claim for violation of privacy and confidentiality. For example, in the Woods case, the district court found that given the most publicized aspect of the AIDS disease, namely that it is affected more closely than more diseases to sexual activity and IV drug use, it is difficult to argue that information about this disease is not information of the most personal kind, or that an individual would not have an interest in protecting against the dissemination of such information. And again, I come back to the idea that the impact on the individual's life is really the stigma that is associated with HIV/AIDS and the impact of the disclosure about that individual's status. We all know that disclosure can take from any number of sources. By the government, a healthcare provider, pharmacist, employer, insurer, friend, and so on. We'll be talking about the case of Stan Cooper, where his HIV status was disclosed among federal agencies. There was a case I recently worked on from ALRP representing 5 individuals who were involved in a gay film where the plaintiff claimed to have contracted HIV/AIDS during the film. The film was from kink.com, and the 5 individuals included a wealth manager, a museum curator, and a symphony member of the San Francisco Symphony, who, for any number of reasons, obvious reasons, did not want their disclosure identified. And we'll talk about some of the reasons how we were able to protect the identity of these individuals. Some of the more common cases come up from the improper disclosure and release of medical records and insurance claim. Another case from ALRP included an individual who was rear-ended on the Golden Gate Bridge, a member of Kaiser Foundation hospitals, went to the hospital for treatment of the injuries from the rear-ender, wanted compensation from the filed a claim for authorizing the release of his record, said that the to be limited for a period of time during the time he received treatment for his injuries, and were to be limited solely to the treatment for those injuries. Instead, Kaiser took the authorization and released his entire medical record, including, by my count, 58 references to his HIV status. And we'll talk about the resolution of that. Here's one of the more recent class action cases. This was a class action that was brought by the AIDS Law Project of Pennsylvania. It was a case where Aetna sent out a letter to its insureds, and you could see that from the address part of the envelope, it not only had the individual's address, but the purpose of the letter to advise you of the options under Aetna Health Plan when filing prescriptions for HIV medicines. The letter went out to 12,000 people. 12,000 people whose HIV status was disclosed by this letter from Aetna. Aetna ended up settling the lawsuit for $17 million, and a scheme was set up for how to compensate these individuals. All right, those are examples we'd be talking about throughout the course of the presentation. But first, let's talk about the statutory protections that are available to individuals with HIV/AIDS and privacy that are available to them. We've already talked about constitutional rights. Each of those constitutional rights should be pled in a complaint or in the claim letter. Under the federal law, there are two potential acts that have statutory protection for HIV/AIDS status. First is HIPAA, that provides for fines and imprisonment for the disclosure of a person's healthcare information, certainly including HIV/AIDS. And the fines and punishment and incarceration increase with the severity of the disclosure. But there's no private cause of action allowed to an individual to sue for a violation of federal HIPAA or its regulations. This means you don't have a right to sue based on violation of HIPAA, but you do continue to have a right to sue based upon state law. And, even though you don't have the remedy, it's important to tell the defendant as well as the court that confidentiality is critical, is recognized as being protected by federal law. And while there's not an independent separate cause of action under HIPAA, it nevertheless expresses a government's interest in protecting confidentiality and privacy. The second express privacy that would apply to patients with or individuals with HIV/AIDS is the Privacy Act that came about after Watergate and Richard Nixon's numerous violations of privacy. And what it essentially does is to govern the collection, maintenance, and disclosure of identifiable information within federal government records. And it prohibits the disclosure of confidential medical information without the express written consent of the individual whose records they're about to disclose. And the Act does provide for the recovery of what is referred to in the statute as actual damages. We'll see that in this case that Brian mentioned, FAA versus Cooper, that 2006, Stan disclosed that he was HIV positive to the Social Security Administration in order to receive benefits, disability benefits. And in those records, he disclosed he was HIV status. He was in the very point of dying. It was at the time, shortly after he was became very ill, that he was enrolled in one of the early cocktail studies at University of California, San Francisco. And he's alive and he's well and he's thriving. But before that, he needed Social Security disability benefits. His license as a pilot was renewed every 3 years, in that he had to disclose any significant sicknesses or disabilities with the FAA, not Social Security, with the FAA. And at the time, FAA had this rule that banned pilots with HIV from flying because, as it was understood by the FAA at the time, that an individual with HIV/AIDS could become suddenly incompetent and crash a plane. When Twin Towers happened, Social Security wanted to find out how many bad pilots, lying pilots there were. So they asked FAA to send Social Security numbers for all pilots that they had so that it could identify pilots who were lying about Social Security numbers. Operation Safe Pilot was the name of the thing. And so Social Security turned over not only, confirming whether or not a pilot had valid Social Security, and they turned over their records. In Stan's case, they turned over his disability records. FAA saw that he did indeed have HIV/AIDS at the time that he previously applied for a renewal of his license, and they indicted him for 3 felonies. There were a number of pilots who were indicted for other non-disclosures, but Stan's was specifically 3 felonies for failure to disclose to FAA that he had HIV/AIDS. We sued the various agencies for emotional distress for mishandling his medical records under the Privacy Act. Sued for actual damages. Stan was extraordinarily stoic individual. He did not seek out therapy. He did not seek out medical care and treatment for the significant emotional distress that he had when a TV crew showed up and filmed that he had been indicted for not disclosing HIV/AIDS status. The trial court ruled that there was no violation of the Privacy Act. The U.S. Court of Appeals for the Ninth Circuit ruled that the exchange of records was improper and that Cooper had standing to sue. The Supreme Court granted cert. It's a very different court than today, but I think it's a preview of what we can expect from the new Trump court. In preparing the argument for the Supreme Court, my partner Ray Cardozo and Reed Smith focused on one judge. That was Justice Kennedy. And all arguments were shaped and crafted to get him to a 5-4 point. The majority held that the definition of actual damages in the Privacy Act did not include damages for mental or emotional distress. They pointed out that actual damages is a term unknown to the tort law. And therefore, because of the vagueness of actual damages, there was not enough consent or waiver of sovereign immunity. And as a result, it created a Privacy Act created a wrong without a remedy for the most common injury for unlawful disclosure of a person's HIV/AIDS status. Justice Sotomayor made that argument and found that it was, I don't know what the adjective would be. You can imagine it. But that, again, that the pilot Stan suffered unimaginable emotional distress. The conduct of the agency was intentional, but that the majority decision left Stan without a remedy for that violation. State law, this is again the basis for statutory protection of confidentiality of HIV/AIDS status. I can't go over all 50 state laws, but we'll take California as an example. But again, a great resource for whatever state that you're practicing in is from the Center for HIV Law and Policy that will direct you to what the applicable state law is in your jurisdiction for regarding the rights and remedies for disclosure of HIV/AIDS status, as well as when the disclosure might be appropriate. All right, in California, when we have a violation or disclosure of a person's HIV/AIDS status, we refer to three statutes, both as statutory violations as well as a basis for negligence per se. The first of these is Civil Code 56, Section 56, so on. And it's very, very, very broad. It prohibits the disclosure of any healthcare information without a patient's consent. You know, that's kind of obvious. It provides for nominal and note actual damages. California didn't have much of trouble identifying what actual damages is, unlike the US Supreme Court, and it provides for an administrative fine for the disclosure of any healthcare information to most individuals. We'll see their exceptions in situations, and provides a remedy for damages. Specifically for HIV/AIDS, Health and Safety Code section 120975 and 120980 provide the basis for a claim against almost anyone, and we'll get into that in a minute, almost anyone for the disclosure of HIV test results. The statute provides that first, that no person shall be compelled in any type of civil, criminal, or administrative proceeding to identify or provide identifying characteristics of an individual who's had an HIV/AIDS test. And that goes back to our Kink.com case, where they sought to compel the individuals who were in the film to disclose whether or not they were HIV positive. And there's administrative fines for this. 120980 provides that any person who negligently discloses results of an HIV test to any third party that identifies a person with HIV/AIDS will be assessed a civil penalty in the amount of $2,500, and then the sanctions increase according to the conduct of the individual. So this statute is very, very, very helpful in creating an independent cause of action for a civil penalty, but also, as they say, for a basis for negligence per se. Now, you're always going to run up in any type of statute that talks about the disclosure of an HIV test result. And these insurance companies and doctors and defense attorneys will come back, well, we didn't disclose the actual test results. We didn't disclose the test paper that showed the results. Well, come on. A reference, for example, in the case that I mentioned about the rear ender, patient is HIV positive. We argue that that is a disclosure of a test result because the only way that you can get a history of a person with HIV is that the person has had a test result and has confirmed a test result. So, this idiocy of saying, well, we didn't disclose the paper that had the test on it should not be an impediment to you in arguing that the disclosure of a person's HIV status in records is a violation and is actionable. It also provides each disclosure a separate offense. And in the cases, like I said, went through and counted the number of HIV references in the individual's records, and we argued that each disclosure, each time there was a reference to HIV in the medical records, was an independent and actionable result. The statute, curiously, has an exception that says that when the results of an HIV test are included in the medical record of the patient who is the subject of the test, the inclusion is not a disclosure for purposes of this section. Well, there's any number of ways to get around that, but in California, be prepared for that exception. Frankly, nobody has ever caught on to that. It's important to understand, too, that if a client comes to us and says that my test results have been disclosed, it should be understood that there are instances in California and in every state that there are instances when HIV/AIDS status can be disclosed, and that these include to the person's representative, healthcare provider, emergency response employee, and so on. So take a look at whatever exceptions there are to what prohibits disclosure, and to see that you do have an appropriate claim. When there's no right to privacy, when the disclosure is made voluntarily by an individual. And these are kind of tough cases that when we meet with individuals who do have a claim for disclosure, I think that's important to ask that person how many times and how many people know that you're HIV positive, because that really goes to that individual's reasonable expectation of privacy. If a significant number of people, non-healthcare providers, are aware of the individual's HIV/AIDS status, that becomes problematic. Not to the point of no claim, but it becomes problematic. As I say that if there's been a disclosure with consent, if there's been any kind of disclosure with consent, then an individual really can't say that there's been a violation of privacy, because privacy is based upon lack of consent. If there is consent, there's no violation of privacy. The written authorization is important, as I mentioned with the rear ender, that his authorization for the release of records was limited to dates for treatment of his injuries for the rear ender, and specifically excluded HIV status, and specifically included only treatment for those injuries. So it's really, really important to read the written authorization, the scope of the written authorization, and so on. In some states, there is the litigation waiver, that if an individual, for example, has been involved in a lawsuit, this is obvious, but we're saying, involving his HIV/AIDS, then the filing of the lawsuit is an implicit waiver for the confidentiality that attaches to the HIV. Other instances of where there is no confidentiality claim is where the disclosure is required by law. Again, in states, there are reporting requirements of HIV status in states. Some states require the identification of the individual. California does not. These are some of the, but the point of this slide is to make sure that you're aware of what disclosures are required under the law of your jurisdiction before you begin to pursue action on behalf of the client. All right. We've got an individual with HIV/AIDS who is entitled to privacy. We have an individual whose HIV/AIDS status has been disclosed. And we have an individual who did not consent to the disclosure of HIV/AIDS status, and for which there are no exceptions for the disclosure. Now we can turn to what we can do about violations of the individual's right to privacy. These remedies, as I mentioned, are not exclusive. They run parallel with each other. Whenever there's a violation of a person's right to confidentiality, we always talk about the idea of administrative remedies that include a complaint filed with the Office of Civil Rights, as well as, if in California, with the State Attorney General. The goal of the administrative remedy, frankly, is to make sure that it doesn't happen again. It doesn't provide any compensation to the individual, but most individuals who come to us with a violation of claim of privacy they do want compensation, but more often than not, they want to make sure that nothing like this ever happens again to an individual like themselves. And I find that in most instances, that is the motivator. They can detail painfully the experience that they've had with the disclosure of their HIV/AIDS status. It's raw, it's biting, it's hurtful. And most are motivated to make sure, as I say, that it doesn't happen again. So there are two ways to do this. There's the administrative route with the Office of Civil Rights that with this complaint, it doesn't exclude judicial action, but maybe a lever in negotiations. And when OCR does undertake an investigation, they do a thorough job. And in many instances, they will come back and take a look at for example, healthcare providers' safeguards and standards that were in place or should have been in place that prevented the disclosure, and then come up with a remedial course in changing policies and so on. There's a link to the Office of Civil Rights that does have the complete procedure for you to follow, but it's important to know that there's a very, very short time period here that they have to file a complaint within 180 days as a violation. Many times that's a problem for any number of good reasons for the client getting to us. And, you can try to extend 180 days for good cause, but, that becomes a very subjective criteria. But it's if you're within the 180-day period, I'd recommend and suggest that you do go forward with a OCR complaint, as well as a Attorney General complaint as well. Perhaps the hardest conversation that we have with clients is explaining to them the reality of litigation. If we're unable to resolve the matter in through a demand letter, many clients, this is their first experience with litigation, with the court process, which is not known for its pleasantness, collegiality, and even at the time, even justice. I'm going to sound like my grandfather, but in one of my first trials, I prepared a litigation trial book that had everything soup to nuts, all the way from voir dire to closing argument, examinations, cross-examinations, reference and cross-reference to depositions and exhibits and so on. And it was a big binder. I was trying the case. It was an HIV case. Trying the case with an old litigator who had been practicing law in California for more than 35, 40 years. He comes in the first day of trial and he takes a look at the binder and says, "What the hell is that?" I was very proud of it. I said, take a look. It's everything that we're going to do through the course of the trial. And he kind of chuckled and he said, put it away, because I want you to understand one thing, that the very last thing that the law concerns itself with, is the search for truth. And then when the jury would come in, he'd stand up and say, "Showtime." Cynical, yes, but to the point, it does make the point that justice is not always guaranteed, no matter how good the case, no matter how bad the wrong. So when we do sit down with the client. We look at the factors that they have to consider and that we have to consider as their attorney to go over of the pros and cons of litigation. And usually the first, as I say many times, it's the first time that a client has been involved in the litigation process and they come in angry, hurt, depressed, spiteful, revengeful, wanting to be made whole. So this is a process that I like to engage throughout the process with the client to remind them that in litigation is not only the best way to achieve justice. The pros are obvious. The cons are not so obvious, but even more painful. And the irony of a privacy litigation is that privacy is stripped away. That which they seek to protect becomes very, very public, and it many times will take years to resolve. And then we explain to them, the monetary damages that are involved that would include, depending upon the case, the emotional harm, lost wages, special damages, no actual damages when you sue the United States government, and punitive damages. And then we have to be very, very candid to explain to them what our best judgment is as to the likelihood of success in the jurisdiction and venue that we're in. So pre-litigation steps. First one is meet and listen. Meet and listen to the client. It's probably the first time that they've had the opportunity to tell their whole story and to listen to them. After listening to them, lawyers have this practice, this tendency to, here's what we're going to do, here's how we're going to do it, and here's where we're going to get. And that's not always in the best interest of the client. Sometimes it works out, may often work out most of the times, but what is it that the client wants? What's their goal? What's their objective? And we hear about attorney-client privilege and relationship and all that. It's really, I'd like to see it, especially in cases like this, as a partnership, where we work together to understand what the client's objectives are, and then advise the clients on the pros and cons of it. And understanding, us or client can our minds at any point during the relationship. So once we're past that, then you gather all the facts, you get all the documents, you talk to key people involved in the disclosure. You get all the medical records. You may consider at that point of having an independent expert psychologist, therapist, psychiatrist, since most of these claims are for emotional distress, evaluate the impact of the disclosure on this individual and help you again understand what it is, what impact it is from their point of view that the disclosure has had on the individual. Research applicable law, understand your jury, understand composition of jury, do jury verdict research on verdicts in similar cases. Take a look at the courts, federal court, state court, take a look at your judges, understand all local rules. And then once you have all this together, in drafting a complaint, create a discovery plan. And then that's an organic document. Just identify documents that you need to get, persons that you need to depose, identify individuals, most knowledgeable individuals, and so on. Understand critically, obviously, what the statute of limitations is. And again, if you have plenty of time, there's no rush to the courthouse. Develop the best case that you can before filing. Once you have all that in place, and one of the pre-litigation remedies, other than filing with the Office of Civil Rights or State's Attorney General, craft a meaningful and significant, detailed, thorough demand letter. People say, well, aren't you tipping your hand? Aren't you giving the defendant a roadmap of discovery? Well, the interest of the client, yes, you are. The interest of the client is trying to resolve the matter as quickly and as efficiently as you can. And that's really why I prefer to give significant substance to a demand letter that will help resolve the matter. You know, they're not going to roll over. They'll try to wear you down. If you think you might be getting somewhere with the demand letter, you might consider doing a tolling provision, tolling for the statute of limitations, to give you time to engage in meaningful discussions to settle the matter without the rush of an approaching statute of limitations. You know, we all see this anytime that any type of insurance carrier is involved. They want to wear you down. It's kind of a Muhammad Ali rope-a-dope. If they want something, give it to them. If they want something else, give it to them. And you know, you can include in the letter that whatever is disclosed is not to be used in litigation. You get that stipulation early on. But wear them down. They'll try to wear you down, but wear them down. And more often than not, they will do the economic analysis of whether they'll take a look at the cost of defending the case as opposed to a settlement. And as we go through this process, keep the client advised, keep the client informed, let them know what the various offers are, get their agreement to a written response, and obviously all the way things are these days, of course, all communications with the client on these key points should be in writing. Well, if all else fails, sue them. And if it's a big enough case, say like an Aetna case or a Stan Cooper case, the best practice is to involve appellate counsel early on and in every step. Since in approaching litigation, especially in the big class action litigation, you want to make sure that with the advice of appellate counsel, that if you win or if you lose, you want to give yourself a basis for a strong appeal. Sometimes in meeting with the clients, I will show them the litigation process. This is a pretty good graphic of what the litigation process tragically can be. But again, it's a useful device to show them what it is that they can expect. All right, time to file the complaint. And again, the complaint depends on the pleading requirements of your jurisdiction. Is it notice pleading or is it factual pleading? Take a look at before you file the complaint if pre-notice is required for the defendant. In California, in a medical malpractice claim, you've got to give notice to the doctor before suing them. The response to privacy says not medical malpractice, it's a privacy case, so there's no notice to them. Again, filing the complaint, consider the jurisdiction and venue that you have. Identification of the plaintiff, we'll get into that in a minute. But you can overplead on causes of action and claims. We'll get into that into a minute. A problem with class actions involving a governmental entity. You should be aware that in California, and I'm sure in other jurisdictions, that there is a claim filing requirement that you have to file with the government before you file the lawsuit and give them an opportunity to reject it or have it deemed rejected. In a class action, if it's a class action claim, California, for example, requires that the claim filing requirement be specific and you say that it will be a class action. It's not enough to say that the healthcare provider disclosed plaintiff's records as well as those of 1,500 other plaintiffs, patients. Be careful with the government claim statute that you have, and if it requires specificity, be as specific as you can in it. I think that in most parties on the left side of the V are afraid of a demurrer motion to dismiss. I don't think you need to be worried about that because when I was on the defense side of things, I would always do the practice of never file a demurrer unless it's an absolute slam dunk. Reason for that is filing a demurrer or a motion to dismiss only teaches the plaintiff about the deficiencies of the complaint and ways that they can remedy it. In filing the complaint, it's a privacy case. You're there because the plaintiff has had their privacy violated. So the very last thing that they want to do is to file a public pleading that has their name and states that they're filing a lawsuit for disclosure of HIV/AIDS status. So whenever you can, get the stipulation of defense counsel to use fictitious names or initials. In California, cases have recognized that it's appropriate in these instances to do it by stipulation, or you can do it by ex parte application to the court as well, if you can't get the agreement of the defendant. One California court has rejected the use of a pseudonym to protect privacy interests. That's Starbucks v. Superior Court. And noted that the judicial use of DOE plaintiffs to protect legitimate privacy rights has gained wide currency, particularly given the rapidity and ubiquity of disclosures over the World Wide Web. They recognize that initials and DOEs are used in California pleadings. Here are some of the claims and causes of action that you might consider in a privacy claim. HIPAA, as I mentioned, does not provide an independent separate cause of action, but can be pled as a way to identify the government interest in protecting privacy of patients. As I mentioned, create a discovery plan before you file a lawsuit. Have a game plan in mind. Interrogatories, persons, documents that you want, persons you need to have identified. Contention interrogatories are useful in developing theories that the defense has. Depositions, persons most knowledgeable, witnesses, and then expert retentions. But, again, it's an organic document, revise. Consultants, again, depending on the size of the case, if it's a significant class action case, excuse me, you might want to consider the use of a jury consultant for the particular jurisdiction that you have to help you do mock juries, to help shape and refine your arguments, as well as to help you at the time of trial by doing a jury questionnaire and to help you select a trial at the time of trial. As we'll talk about in a bit, what we're doing in a trial is telling a story, and telling a story with a theme, with a persuasive, compelling theme. And a graphic artist can be useful in large cases in helping you develop that theme. And also, as I mentioned, appellate counsel to help guide you on avoiding pitfalls in your case that will make it more difficult on appeal. All right. The time of trial, any trial, a small trial, big trial, any trial, has what's your theme? What's your theme? Start strong, finish strong. The first thing that you say, primacy, and the last thing that you say, recency, are two parts that are very likely to be remembered by a jury and a judge. Make sure that you start strong with relevant and attention-grabbing statements, statistics, facts, or engagement of the audience. You have 30 to 60 seconds to grab your audience's attention. Your theme is your anchor. You're wasting time with pleasantries, welcomes, thank yous. We know it's difficult. We appreciate your time, housekeeping, or any of that. End strongly with a memorable quote, call to action. Leave them with a message that is going to keep them thinking and encourage them to act and take on board what you have just spoken about. Know your judge. Shape your trial with recency, primacy, and technology. We'll get to this as to why is important. My friend says it's useful to have a trial book. And in a privacy case, as well as any case, the best way to present the facts of a case is to tell a story. The most memorable stories are those which both illustrate a moral and which can be summed up in a phrase or two. In trial, the moral to our stories is our legal theory, and the phrase or two which captures the essence of our moral legal theory is our trial theme. Mercifully, juries are very different from what we see here in so many, many ways, but whoever is on your jury, you want something that will grab their attention and hold their attention. Consider this. The average attention span for a goldfish is 9 seconds. According to a study from Microsoft, people now generally lose concentration after 8 seconds, highlighting the effects of an increasingly digitalized lifestyle in the brain. The Microsoft study found that since 2000, the average attention span dropped from 12 seconds to 8 seconds. You've got a very brief period of time. You know, sometime turn the sound off the TV and just watch how a film, how a series is presented. And it's pop, 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 light, dark, color, pop, pop, pop. The idea of a theme is important. You know the facts, you know the law, but what's the theme? You want to come up with contrast in your theme of good, bad, small, big, innocent, sophisticated, personal versus anonymous, so on. And one of the examples that I really like was a theme that was developed in this personal injury case. And in the case, the plaintiff was injured by a John Doe hit and run driver. Her injury was to her rib cage, and she testified that it hurt every time she breathed. Her doctor agreed that this was possible. Liability, of course, was not much of a problem, and the focus of the trial was on damages. Without actually using the themes, without actually using the words, the theme used was from the popular song, Every Breath You Take by the Police. That every move she makes, every breath she takes, she will be in pain. The jury was asked to watch over her. After the trial, the jurors mentioned that they indeed thought about the song during their deliberations. So you have the facts, you have the law, and what is your theme? And the theme is to be presented throughout the time of the trial with your witnesses, with your documents. Because remember, you've only got about 8 seconds to grab their attention. Stigma is powerful, stigma is hurtful, stigma is damaging, stigma is destructive. It is the stigma that is the core of your claim and your action for a violation of privacy. As a reminder, we have the Equality Act to deal with. The scabs in the US have been scraped off. HIV/AIDS stigmas exist more so than ever. The surface has changed, but irrational hatred persists. And litigation is one resource that we can begin to use to solve this. About Mary Smith. We didn't go to trial, but we settled with the transportation agency who, with a demand letter, adopted a training program for HIV privacy and confidentiality. They also paid a sum of money to Mary, who gave a party for her boyfriend and her family. And she wanted to be left alone. So thank you for your time. And to the extent that we have any time, I'd be happy to take your questions.
I think if we have any questions, you all could put them in the chat and Jim could answer them if you have any. You can also always email me later if you have any follow-up questions for Jim, and I'd be happy to pass them on.
Thanks, Stephen.
Great. Well, thank you so much, Jim. Thank you, everybody, for showing up. If you could please complete the survey after you're done with this webinar. That way I can get you your MCLE certificate. I know some people called in. So if you did, please email me and I will send you a copy, or I'll send you a link to the survey so that make sure you all get your MCLE units. So thank you everyone for coming. Appreciate it.
Take care all.